There's a knock at your door. Not the doorbell, not a text saying, "Hey, I'm outside." A knock, firm, a little too even to be a neighbor or a delivery driver, and through the peephole you see a uniform. And in that exact second, before you've even decided whether to move toward the door at all, a decision is already forming that most people get completely wrong, not because they're careless, but because nobody ever actually sat them down and explained what their front door legally means. Here's what I want you to walk away from this video knowing. Cold, without having to think about it under pressure. Your home is the single most protected space in the entire legal framework of this country. More protected than your car, more protected than the sidewalk, more protected than almost anywhere else you could be standing. And the moment you open that door, a huge amount of that protection can quietly start slipping away, one small decision at a time, often without you ever realizing it was happening. Before we get into exactly what to do, if you want to actually know your rights instead of guessing and hoping for the best the next time someone's standing on your porch, hit subscribe right now, because that's exactly what this channel exists to give you. Quick note before we start. This is legal education and commentary, not legal advice for your specific situation, and some details shift state to state, but the core principles hold up almost everywhere in this country. Let's get into it. Let's start with the single most important legal fact underlying this entire video, the one thing that changes how every other rule applies. Your home receives the strongest protection under the Fourth Amendment of anywhere you can be. The Fourth Amendment protects against unreasonable searches and seizures, and courts have consistently treated the home as the place where that protection is at its absolute peak. Stronger than a car, stronger than a workplace, stronger than nearly anywhere else in your life. That elevated protection exists for a reason, rooted deep in the founding of this country. The framers had lived through a world of officials entering homes at will, and they built a specific, deliberate wall against exactly that kind of intrusion. That wall still stands today, and it's yours, whether you rent or own, whether it's a house or an apartment, whether officers arrive with lights and sirens or quietly in an unmarked car. Understanding that this wall exists, and understanding how it actually works, is the entire foundation everything else in this video is built on. So let's talk about the very first thing that matters, before anyone's even spoken a word through the door, and it's this. You are not required to open your door for police. Full stop, in the overwhelming majority of situations. There's no general obligation that says a knock creates a duty to answer, the same way there's no obligation to answer your phone just because it's ringing. You can look through the peephole, see the uniform, and simply not open the door at all, and doing so is not illegal, is not obstruction, and is not evidence of anything at all. I know this feels counterintuitive to people who've grown up assuming that police at the door means you have to engage, but the starting position, legally, is exactly the opposite. The door stays closed unless you decide otherwise, and that decision is entirely yours to make. Now, there's an important exception sitting right underneath that general rule, and I want to walk through it carefully, because this is where a lot of the actual complexity in this topic lives. If officers have a valid search warrant or a valid arrest warrant, the calculus changes, and I'll walk through exactly how in a moment. But if they're simply knocking, without a warrant, hoping you'll open the door and either let them in or start talking, that's what's sometimes referred to as a knock and talk. A completely voluntary, consensual encounter from your side of the door, and voluntary means you get to decide how much of it you actually want to participate in. Let's talk about what to do the moment you hear that knock, step by step, because the sequence you follow here matters more than people expect. First, don't panic, and don't rush to the door. Take a breath, walk over calmly, and look through the peephole or a window if you have one, just to get a sense of who's actually there before you do anything else. This isn't about being paranoid. It's simply about gathering information before you make any decisions. Exactly the same instinct you'd use for any unexpected knock at any hour. Second, you do not have to open the door to talk. You can speak clearly through the closed door, or crack a window if one's nearby, and this is actually the position that preserves the most protection for you, because stepping outside or opening the door wide can sometimes change how courts look at what happens next. If you want the strongest possible footing throughout this entire interaction, keep the door closed and speak through it for as long as you need to. Third, the very first question you ask, before anything else, is simple. Do you have a warrant? This single question does more to clarify the entire situation than almost anything else you could ask, because the answer to it determines which of two very different sets of rules applies to everything that happens next. Let's talk through what happens with each answer, because they lead down genuinely different paths. If the answer is no, no warrant, they're just there to talk, ask a few questions, follow up on something, then you are under no obligation to let them in, no obligation to answer questions, and no obligation to open the door at all. You can say, calmly and politely, through the door, "I don't consent to you entering, and I don't have any questions I'd like to answer right now. If you'd like to leave your information, I'll follow up if needed." That's a complete, respectful response, and it costs you nothing. If they push back, "We just want to ask a few quick questions. It'll only take a minute. We're not here to cause trouble." None of that changes the underlying situation. You can simply repeat the same thing. "I understand, but I don't consent to entry, and I'd rather not answer questions right now." You are allowed to be firm here without being rude, and firmness is exactly what protects you, because officers without a warrant are relying entirely on your voluntary cooperation, and voluntary cooperation is something you're allowed to decline. If the answer is yes, there is a warrant, the next move is to ask them to hold it up to a window or slide it under the door so you can actually read it, because not all warrants are the same, and what a warrant says matters enormously. There are two fundamentally different kinds of warrants that might come up here, and understanding the difference changes what you're actually required to do. The first is a search warrant. A search warrant authorizes officers to search a specific place for specific items, and critically, it needs to be signed by a judge, and it needs to specify exactly what can be searched and where. A valid search warrant generally does give officers the authority to enter your home, whether or not you personally consent to it, because a judge has already reviewed evidence and determined there's probable cause to justify that search. If you're shown a search warrant that appears valid, signed by a judge, specifying your address, describing what's being searched for, you are not required to physically block officers from entering, and doing so can result in serious charges of its own. What you can do, and what you absolutely should do, is state clearly, for the record, "I don't consent to this search, but I understand you have a warrant, and I'm not going to physically interfere." That sentence matters because it preserves your ability to challenge the warrant later, its validity, whether it was executed properly, whether the search stayed within its stated boundaries, without you having done anything that could be treated as obstruction in the moment. The second is an arrest warrant, and this works differently, and the difference here is genuinely important. An arrest warrant authorizes officers to arrest a specific named person. It does not, by itself, generally authorize a full search of your entire home. If officers have an arrest warrant for someone believed to be inside your home, there's a meaningful legal distinction between them entering to locate and arrest that specific person, and them using that same warrant as a justification to search through your belongings, your drawers, your closets, unrelated to locating that person. If you're shown an arrest warrant rather than a search warrant, it's worth stating clearly, "I see this as an arrest warrant. I don't consent to a search of my home." That doesn't necessarily stop officers from entering to look for the person named in the warrant, if there's reason to believe that person is inside, but it does put on the record that any broader search beyond locating that individual isn't something you agreed to. Let's talk about what a valid warrant actually needs to have, because this matters if you're ever trying to assess one in the moment. It needs to be signed by an actual judge, not just filled out by an officer. It needs to specify a particular address, not a vague or general area. If it's a search warrant, it needs to describe with reasonable specificity what's being searched for and where officers are authorized to look for it. A warrant that's clearly for a different address, that's unsigned, that's expired, or that looks obviously incomplete, is worth pointing out calmly. "This warrant appears to be for a different address," or "I don't see a judge's signature on this." Not as a way to start an argument, but as a way to create a clear record of a potential problem that an attorney can examine properly afterward. You're not trying to win a legal debate on your own porch. You're simply making sure that if something is wrong with the warrant, that fact exists somewhere other than just your own memory of the encounter. Now let's talk about a scenario that comes up constantly and causes a huge amount of confusion. What happens if officers say they don't have a warrant, but claim they have what's called exigent circumstances, meaning some kind of emergency that justifies entering without one? This is a real, recognized exception to the general warrant requirement, and it covers situations like someone screaming for help inside, visible evidence that's about to be destroyed, or an active, ongoing emergency that can't wait for a warrant to be obtained. If officers claim exigent circumstances and move to enter without your consent, understand that physically blocking them in that moment is not the move, the same way it isn't with a valid search warrant. You state clearly that you don't consent, you don't physically interfere, and you save the question of whether exigent circumstances genuinely existed for exactly the setting built to examine that question properly, which is a courtroom with an attorney, months later, not your doorway in the moment it's happening. This is actually one of the more frequently challenged areas of search and seizure law, precisely because the exception can be stretched or misapplied, and that's exactly why the fight over whether it applied correctly belongs in front of a judge, not on your porch. Let's talk about something that trips people up specifically, the difference between your porch and the interior of your home, because this boundary matters more than most people realize. If you step outside to talk to officers, even briefly, even just to hand them something or close the door behind you first, you've generally left the strongest zone of protection and entered a more ambiguous space, closer to the kind of public encounter we've covered in other videos on this channel. If you want to preserve the maximum protection your home offers, the better move, every time, is to stay inside and speak through the door or a cracked window, rather than stepping out onto the porch to have the conversation face to face. It feels a little unusual, maybe even a little rude, to conduct an entire conversation through a barely open door. But it's not rude, and it's not unusual once you understand what it's actually protecting. Officers are trained to expect and work around exactly this kind of interaction, and doing it this way costs you nothing in terms of how the encounter unfolds while preserving significantly more of your legal position than stepping outside would. Let's talk about what happens if there's a knock and it's not about you specifically. Officers looking for information about a neighbor, a witness, someone connected to an investigation that has nothing to do with you directly. The exact same framework applies here. You are not required to answer questions. You're not required to let anyone in, and declining to participate in a voluntary conversation is not evidence of anything at all, regardless of whether you personally have anything at all to hide. I don't have any information I'd like to share right now, but I appreciate you stopping by, is a completely fine thing to say, closes the conversation politely, and leaves the door exactly where you want it, closed, on your terms. Let's talk about consent, specifically, because this is really the center of gravity for this entire video, the same way it's been the center of gravity in almost every video on this channel about interactions with police. Without a warrant, the only way officers generally get to enter your home is with your consent, and consent has to be genuinely voluntary, not something extracted through pressure, confusion, or a misunderstanding about whether you actually had a choice. This means you're allowed to say no. You're allowed to say no even if you've done absolutely nothing wrong. Even if your home is completely spotless and there's nothing anyone could possibly find, even if saying no feels awkward or uncomfortable in the moment. Declining entry is not suspicious. It's not obstruction. It is the single most straightforward, lawful thing you can do to preserve a protection that exists, specifically so this decision belongs to you. I want to spend a moment on why good, honest people struggle with this specific moment more than almost any other in their entire relationship with law enforcement, because it's genuinely different from declining a search in your car or declining to answer a question on the street. Your home feels personal in a way almost nothing else does. Saying no to someone standing on your own porch, in front of your own door, can feel almost rude in a way that declining a car search on a public roadside doesn't quite replicate. There's a social instinct wrapped up in it. An instinct about hospitality, about not seeming difficult, about wanting to seem like a cooperative, reasonable person in your own neighborhood where people might be watching. That instinct is completely human, and it's exactly the instinct worth being aware of in this specific moment, because it's the one most likely to talk you into opening a door you'd otherwise have every right to keep closed. Let's talk through the exact phrases for a handful of common scenarios, because I want you leaving this video with specific words ready to go, not just a general sense of the principle. If officers knock and simply say they'd like to come in and talk, I appreciate you stopping by, but I don't consent to you entering my home. If there's something specific you'd like to discuss, I'm happy to talk through the door, or you can leave your card and I'll follow up. If they say they just have a few quick questions, I'd rather not answer questions right now. If this is something I need to address, I'll do that with an attorney present. If they say refusing makes it look like you're hiding something, I understand that, but declining isn't an admission of anything, and I'd still like to keep this conversation limited to what I've already said. If they present something and claim it's a warrant, could you hold that up to the window so I can read it? Followed by, once you've seen it, either, I don't see this authorizes entry to search my home, so I don't consent to that if it's an arrest warrant for someone else or unclear in scope, or, I don't consent to this search, but I understand you have a warrant, and I won't interfere with you executing it, if it does appear to be a valid search warrant for your address. If they say they'll get a warrant if you don't let them in voluntarily, that's completely understandable, and I still don't consent to entry without one. This is actually a healthy outcome, even though it doesn't feel that way in the moment, because it means a neutral judge, not the pressure of a doorstep conversation, is the one deciding whether entry into your home is actually justified. Let's talk about what happens after officers leave, if that's how the encounter ends, because just like with a traffic stop, what you do in the minutes immediately afterward matters more than people expect. Write down or record a voice memo capturing everything you can remember: what time it was, roughly how many officers there were, what was said, whether a warrant was shown and what it looked like, badge numbers or names if you caught them, and anything specific that was said about why they were there in the first place. Memory fades fast, and if anything about this encounter ends up mattering later, a dispute about whether consent was actually given, a question about whether a warrant was valid or properly executed, your own contemporaneous notes become genuinely valuable, and they cost you only a few minutes. Let's talk about a related scenario that deserves its own attention. What happens if officers are already inside your home for a legitimate reason? Maybe you called them yourself for an unrelated emergency, and partway through, the conversation shifts towards something that starts to feel like it's about you specifically. The same underlying principles still apply even once someone is already inside. You can withdraw consent for them to remain if they entered with your permission in the first place, and you can decline to answer additional questions, even in the middle of an ongoing conversation. I appreciate your help with this, but I'd rather not get into anything else right now, is a completely valid thing to say partway through an interaction, even one that started on completely different terms. Let's talk about landlords, roommates, and shared living situations, because this adds a layer of complexity worth understanding specifically. Generally, anyone with common authority over a shared space, a roommate for instance, can potentially consent to a search of shared areas, even if you personally object, though this typically doesn't extend to areas that are clearly and exclusively yours, like your own locked bedroom, even within a shared home. A landlord generally cannot consent to a search of a tenant's rented unit on the tenant's behalf, because the tenant, not the landlord, holds the relevant expectation of privacy in that space during the lease. If you're in a shared living situation and this scenario ever comes up, understanding that your own explicit refusal matters, even if someone else in the home is more willing to cooperate, is worth knowing in advance, well before it ever becomes a real situation playing out in real time. Let's talk about something a lot of people don't think about until it's already happening. What to do if you're not actually home when officers show up, but someone else is. A family member, a roommate, someone house-sitting. It's genuinely worth having this exact conversation, calmly, in advance, with anyone who might reasonably answer your door in your absence, because the instinct to be helpful and cooperative to a uniformed officer standing at the door doesn't disappear just because the home isn't technically theirs. The same framework applies regardless of who's answering. No obligation to open the door, no obligation to let anyone in without a warrant, no obligation to answer questions. And it's worth making sure that framework is understood by everyone who might find themselves standing on the other side of that door when you're not the one there to handle it yourself. Let's talk about recording this kind of encounter, because it's just as relevant here as it is with a traffic stop, maybe even more so given how much can hinge on the exact wording used and the exact sequence of events. In most places, you're allowed to record an encounter with police at your own front door, the same way you're generally allowed to record them performing public duties elsewhere. A doorbell camera, if you have one, is already doing exactly this kind of documentation automatically, and it's genuinely one of the most useful tools available for this specific scenario, because it creates an objective record of exactly what was said and exactly what happened, removing any question later about whose memory of the conversation was accurate. Let's bring this all the way back together, because I want to leave you with one clear, simple structure rather than a long list of separate rules to try to remember individually under pressure. Your home carries the strongest legal protection of anywhere you're likely to be, and that protection exists specifically so that a knock at your door does not, by itself, create any obligation on your part. You are not required to open the door. You are not required to let anyone in without a valid warrant. You are not required to answer questions, and declining to do any of these things is not evidence of anything, regardless of what's actually true about your situation. The very first question, always, is do you have a warrant? Because the answer determines everything that follows. Without one, the entire encounter remains voluntary from your side, and you can decline as much of it as you'd like, calmly and respectfully, without ever opening the door at all if you don't want to. With 1, read it carefully, understand what kind it is and what it actually authorizes, comply physically without resisting entry if it's genuinely valid, while still stating clearly, for the record, that you don't consent to anything beyond what the warrant itself specifically requires. Let's go further, because there are a handful of situations connected to this exact scenario that deserve their own careful walkthrough. Ones that don't come up in every encounter but matter enormously in the specific moments where they do. Let's talk about Child Protective Services and welfare checks, because this is one of the more emotionally loaded versions of a knock at the door, and it's worth handling with real care, specifically because the instinct to fully cooperate immediately, out of fear of how refusal might look, runs even stronger here than it does with police. If someone from a child welfare agency shows up at your door, understand that in most places, without a court order, you are not required to let them into your home, and you are not required to allow them to interview your children without you present. Though the specific rules here vary more by state than almost anything else covered in this video, and the stakes involved make it worth understanding your specific state's approach in advance, rather than learning it for the first time mid-conversation. What you can say, calmly, is something like, "I want to cooperate, and I'm happy to discuss any concerns, but I'd like to understand what specifically prompted this visit, and I'd like to have an attorney involved before allowing an interview or a home inspection." This isn't about being uncooperative. It's about making sure that if there's a serious allegation involved, you're navigating it with proper guidance rather than purely on instinct in a moment specifically designed to feel urgent and high pressure. If there's ever a court order involved, similar to a warrant, that changes the calculus the same way a warrant does with police, and it's worth asking to see it and understanding exactly what it authorizes before proceeding. Let's talk about process servers and civil matters, because not every knock at your door involves police at all, and it's worth understanding how this differs. If someone shows up to serve legal papers, a lawsuit, a subpoena, divorce paperwork, the situation is fundamentally different from a criminal law enforcement encounter, and refusing to open the door doesn't actually prevent service in most places, because process servers can often complete service by other means, like leaving papers at your door, or with another adult at the residence, depending on your state's specific rules. There's genuinely less to be gained by refusing to engage here compared to a police encounter, since the legal document exists and needs to reach you regardless, and avoiding it typically just delays things rather than preventing them, sometimes to your own disadvantage if a deadline starts running from the date of attempted service rather than actual receipt. Let's talk about code enforcement and municipal inspectors, because this is another category people sometimes lump in with police visits when it actually works quite differently. A city inspector showing up about a permit issue, a code violation, an unpermitted addition to your property, generally cannot enter your home without either your consent or, in some cases, an administrative warrant, which is a slightly different legal tool than a criminal search warrant, but still requires some form of judicial authorization in most circumstances. The same basic principle holds. You're not required to let someone in simply because they're carrying a clipboard and a municipal badge instead of a police badge. And asking, "Do you have a warrant, or can we schedule this through my attorney?" is a completely reasonable response here too. Let's talk about what happens if officers claim they're just there for a welfare check, on you specifically, meaning someone called concerned about your safety, because this scenario deserves particular care given how emotionally charged it can be. If you're genuinely fine, you can simply say so through the door. "I'm okay. Thank you for checking. I don't need anything right now." And in the vast majority of situations, that resolves the matter completely, because a welfare check exists to confirm someone's safety, not to conduct an investigation. If officers push for entry anyway, citing concern for your well-being, understand that genuine concern for safety can sometimes justify entry under exigent circumstances if there's a real, specific reason to believe you're in danger, but a general, unspecified concern typically doesn't override the same warrant requirement that applies everywhere else. You can say, "I appreciate you checking on me, I'm safe, and I don't consent to entry," clearly and calmly, and that statement matters, creating a clear record that entry beyond that point wasn't something you agreed to, regardless of how the situation unfolds from there. Let's talk about apartment buildings and multi-unit situations specifically, because there's an added layer worth understanding if you live somewhere with shared entryways, hallways, or common areas. The protection we've been discussing throughout this video applies specifically to your actual unit, your apartment itself, and generally doesn't extend the same way to shared hallways, lobbies, or common areas that other residents in the building itself have access to. This means officers walking through a shared hallway to reach your door isn't the same as officers entering your actual living space, and it's worth understanding that distinction so you're not surprised by officers being present in a shared hallway outside your door without that alone representing any kind of violation of your rights, while the door to your actual unit still carries all the same protection we've spent this entire video walking through. Let's talk about something worth addressing directly. What if you already made a mistake and you already let someone in, or already answered questions before knowing any of this, and now you're wondering what to do from that point forward? First, exactly like we've said in other videos on this channel, don't panic and don't try to walk anything back verbally in the moment, because attempting to retract statements or explain them differently after the fact rarely helps and often adds confusion rather than clarity. What you can do, even partway through an encounter that's already underway, is simply stop and change course from that point forward. I'd like to stop answering questions, and I don't consent to anything further beyond this point. That doesn't erase what's already happened, but it prevents the situation from continuing to develop unfavorably, and it preserves your ability to have a clear, honest conversation with an attorney afterward about exactly what was said, what was allowed, and what your options look like moving forward from there. Let's talk about the emotional layer of all of this for a moment, because a knock at your own front door carries a very different kind of weight than being pulled over in your car, and it's worth acknowledging that directly, rather than pretending this topic is purely mechanical. Your home is supposed to be the one place where you feel completely secure, completely in control, completely free from the kind of pressure that shows up elsewhere in life. And an unexpected knock from law enforcement disrupts that feeling in a way that's genuinely unsettling, even for people who've done absolutely nothing wrong. That disruption is exactly why this specific scenario deserves the kind of careful, calm preparation we've walked through in this video. Because the version of you standing there in the moment, heart pounding a little, is not the ideal version of you to be improvising complex legal decisions for the first time. The preparation happens now, in advance, sitting somewhere calm, specifically so that if this moment ever actually arrives, you're not inventing your response from nothing. You're simply recalling something you already thought through carefully, long before you needed it. Let's talk about one final piece worth understanding: the difference between being polite and being compliant. Because this distinction runs through this entire video, and it's worth stating explicitly one more time before we close. Every single sentence we've covered in this video can be delivered warmly, respectfully, even apologetically in tone, without losing a single ounce of its legal effect. I really do appreciate you stopping by, and I don't mean any disrespect, but I don't consent to entry without a warrant. Accomplishes exactly the same protection as a flat, cold version of the same sentence. And the warm version is almost always the better choice, both because it tends to keep the actual interaction calmer and more pleasant for everyone involved, and because there's simply no reason to sacrifice basic courtesy in order to assert something that's entirely yours to assert. Politeness and firmness are not opposites here. They work together, and the version of you that handles this calmly, warmly, and clearly is the version that comes out of the encounter in the best position, every single time. Let's close by pulling this entire framework back together one more time, because I want it sitting clearly and completely in your mind before we wrap up. Your home carries the strongest protection available anywhere in your life, and a knock at your door does not, by itself, create any obligation to open it, to let anyone in, or to answer a single question. The first move, always, is to ask calmly whether there's a warrant, because that single answer determines the entire shape of everything that follows. Without one, the whole interaction remains voluntary, and you can decline as much of it as you choose, calmly, respectfully, through a closed door, if that's what you prefer. With one, take the time to actually read it, understand exactly what kind it is, and exactly what it authorizes. Comply physically, without resisting a valid warrant's execution, while still stating clearly, for the record, that you don't consent to anything beyond its specific scope. And through every version of this, police, welfare checks, code enforcement, anyone at all standing on the other side of that door, the same underlying truth holds steady. This is your home, this is your door, and the decision about what happens next belongs to you, until a judge, not a badge, says otherwise. Say the key sentences out loud one more time, because saying them now, calmly, in your own kitchen, is what makes them instinct instead of invention later. Do you have a warrant? I don't consent to you entering my home. I don't consent to this search, but I won't interfere with a valid warrant. I'd rather not answer questions right now, but I appreciate you stopping by. 4 sentences, warm and complete, ready whether that knock ever comes or not. If this filled in something you didn't have clearly in mind before today, hit subscribe, because there's more of this coming, one real scenario at a time. The kind of preparation that turns an unsettling knock into something you can handle calmly, instead of something that catches you completely off guard. Stay calm, know exactly what that door protects, and remember that it's yours to open only when, and only if, you actually choose to.